with a term of prison of 14, a minimum term of 14, maximum term 16 and a half. There is a restitution request of $760.38 to Vendola Lawrence for the vehicle. And Ms. Lawrence is present today, and my understanding is she does wish to make a victim statement.
What was that amount?
$760.38.
That's okay. Okay.
Let me look it up. Zero help.
I know.
Good morning.
Good morning,
Would you please state your name for Ms. Schlim?
Vendola Lawrence.
Ms. Lawrence, what would you like me to know?
I condensed what I had to say into a few sentences. Mr. Damian Dittis, I just need to know why me? What did I do to possess you to steal my 2019 Nissan Maxima on the west side of Dayton? My blanket from my mother is missing. The car manual is missing, and approximately $100 in cash was gone, I should say. I had to pay for deductible for my car to my car insurance for the repairs of my car once I received it back. As a consequence, you caused fear in me and my neighbors on my street. I wake up during the morning or late at night, looking out of my window from my house, checking to see if someone lurking in my neighborhood. And the bottom line, I just want Mr. Damian to know that I do forgive him for stealing my vehicle. I really do.
Thank you.
You're welcome.
Ms. Tranter, is there anything else?
The only thing additional, judges, I am showing that he does have 2 days jail credit.
All right. Anything from probation?
Nothing further, Your Honor.
All right. Mr. Fox.
Thanks, Your Honor. I have prepared an affidavit of indigency. We would ask the court to go along with the agreed sentence. As to the victim impact statement, just so the victim is aware, Mr. Dennis actually purchased that car, so he is not the person who stole it, but he has agreed to pay the restitution. Your Honor, Mr. Dennis, I came in late on representation. He was offered a much smaller number at a prior time. And unfortunately, at that point in his relationship with his prior counsel, he was not aware of how great of a deal that was. I've spent considerable amount of time with him and got to know him very well. He's a wonderful father who's going to miss his kids dearly, as the court knows. If it goes along with the agreed sentence today, he will be doing over a decade in prison, nearly a decade and a half. So it's been a very tough time for him to get to this point, but we're grateful for the officers and the state of Ohio for agreeing to reduce their previous offer and go along with the agreed sentence. And I do have that affidavit.
All right. Thank you. Mr. Dennis, is there anything you'd like the court to know?
I just want to apologize to the victim. I've never been to the west side of Dayton in my life, but I am sorry about your partner. So.
All right. The court has considered the statements made here today, the purposes and the principles of sentencing, the relevant seriousness and recidivism factors. The court has also considered the agreed recommended sentence of the parties and finds it to be an appropriate sentence. So on count one, the court will order you to serve a period of incarceration. What was that number that was agreed to?
14.
14 total.
All right. So on count one, the court will order you to serve a minimum term sentence of 11 years, and on the specification, 3 years. By law, that must be served prior to and consecutive to count one. So that's 14 to maximum term sentence would be 19 and a half. On count three, the court will order you to serve a period of 18 months, that to be served concurrent to count one.
Judge, count 3 is an F1. I think what we had discussed previously.
My numbers are just, on my notes are different than what I guess, okay, so it's going to be 3 years, right? Concurrent. Count one, I'm ordering him to serve the 11 to 16 and a half, correct?
Correct.
There's a 3-year specification.
That is a major drug offender specification, Judge. It's not a firearm specification. So to count.
Oh, that
one,
makes it mandatory. Never mind. I'm
right,
sorry.
that makes it
That's where my notes are really screwed up. Okay. So it's 3 years on count 3 to be served concurrent, right?
Actually, no, Judge, not to correct you again, but
Tell me what your
so here's
my notes just don't.
I know we had a long discussion the
It
last time.
went back and forth a little bit. So on count one, it's
So-
11 to 16 and a half.
11 to 16 and a half, correct. And that is due to the major drug offender
All right,
specification.
count 3 is 3 years
Count 3
consecutive.
Count 3 is there's also a major drug offender specification on that. So it also has to be 11. Because it is fentanyl related, then that's where the 3 years, the additional 3 to 8 come in. So the additional 3 comes from the specification on count 3. So it'd be 11 on count 1, 11 on count 3. Those are to run concurrent. And then 3 on the major drug offender specification for the fentanyl to run prior to and consecutive.
All right, I'll get this right, Mr. Dennis. Hang on. So it's 11 concurrent, 3 years on the spec on count 3. That's consec.
Correct.
And then 18 months concurrent on count 6
Correct.
and 12 months concurrent on count 7.
That's correct.
All right, so 1, 3, spec, 5, I'm sorry, 6 and 7. Okay, so I'll start over. The agreed recommended sentence of the parties, which the court approves on count 1, the court will order you to serve a minimum term sentence of 11 years, maximum term sentence of 16 and a half years. On count 3, the court will order you to serve 11 years, that to be served concurrent with count 1. The specification on count 3 is a 3-year specification by law that must be served prior to and consecutive to count 1. On count 6, 18 months in prison, that to be served concurrent with count 1. And on count 7, 12 months in prison, that to be served concurrent with count 1. As I said, by law, the consecutive sentence is required. So I do not need to make any specific findings with regard to why the court is ordering a consecutive sentence. The court does find that you have 2 days jail time credit. The court will order you to pay the restitution of $760.38 to Ms. Lawrence. Other than that, the court has received the affidavit and will find you to be indigent for the purposes of any other fines, costs, or other financial sanctions. Now, other than the mandatory time, I guess this is all mandatory. It makes it mandatory, doesn't it?
It is.
All right, now you are also subject to a mandatory period of post-release control, which means upon your release from prison, the adult parole authority will supervise you for a period. I'm just not ready for this morning, I guess. Of up to 5 years, but not less than 2 years. If you violate those terms of supervision, the adult parole authority can return you to prison for up to 1/2 of this court's original minimum term sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time that you get sentenced to. You do have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, that can all be provided to no cost. If you cannot afford an attorney, I will appoint one for you at no cost. All right, at this time, is there anything else?
I don't believe so, Judge.
All right,
Thank
this
you.
time you are remanded into the custody of the Warren County Sheriff's Office for transport to the Department of Corrections. Okay. Thank you, Mr. Fox. Thank you.
Corporate representative they designated that did not attend his deposition, who led to that motion for sanctions, for show cause and sanctions, and led to the court's order of January 16th. As the court is aware, last night, after receiving this designation on Friday, we filed a motion to exclude all testimony from the May 2025 deposition. Additionally, as counsel has just indicated, we filed counter designation and objections to each and every aspect of the designated testimony, because the testimony of Mr. Chuden, when you look at it in totality, gets back to things that he does not have personal knowledge. If you look at the testimony, he does not have anything other than hearsay. He does not have anything other than speculation. And the only testimony that he has in there would be related to his role as a corporate representative. The court has already ruled on this issue and said that testimony is inadmissible in this trial. The testimony is being sought to be excluded because it is already determined in this case to be inadmissible. And we request that the totality of that May 2025 deposition be excluded from trial, Your Honor.
Anything in response?
Just briefly, Your Honor, you can't look at it in totality. I mean, that's not how deposition designations are assessed and examined. You know, it's easy to lump it all together and look at it in totality, but the actual conversations that my client had with veteran, the actual real-time email exchanges were matters of which he had personal knowledge, and we believe at the very least those parts should come in. That's all I'm going to say. Thank you, Your Honor.
Thank you. Well, as I indicated in chambers, I've read the judge's order. That order is the law of the case as we sit here right now, and that order finding Select Corporation in contempt of the November 12th order to conduct the second deposition of Mr. Chayudin stands. The judge's finding of contempt and the accompanying sanctions motion and his order with respect to that from January 16th of this year indicates that Select Corporation is prohibited from presenting any evidence or testimony related to the corporate representative, Mr. Chayudin. I take that to mean Mr. Chayudin's testimony or any evidence related to him is prohibited. That is the law of the case. I am not going to overturn Judge Oda's order. So I am going to, I'm not going to let Mr. Chayudin's prior deposition come in. So with that, I think Mr. Zalet, another issue?
Yeah, a couple more issues. Understood, Your Honor, and
Okay.
thank you for taking the time to consider that. Two other things. We'd like to renew today our motion to continue this trial. I know it's already been briefed and ruled upon, but I looked back on the briefing, the ruling. I checked the due process clause of the U.S. Constitution and did a little research and, learned that that clause applies in civil proceedings. We believe that going forward with this trial denies due process to Select. Mr. Kuhinen is unavailable today, and that's kind of beyond his control. I'm not going to get into that, but our motion for continuance was not indefinite. There will be certainty within the next 30 days as to Mr. Chudin's availability. So we'd like to renew that motion. We believe having the trial of the rights and liabilities, well, the rights of Select in his absence is violative of the due process clause. And we believe that a continuance of a set duration would remedy that, 30 days even. It's not indefinite. So we're renewing that motion with a slight amendment that it be continued for 30 days and a date thereafter that's convenient for the court and the parties.
Mr. Dunn?
Thank you, Your Honor. Veteran Logistics would object to the motion to continue it, Your Honor. Parties are here. We're prepared to move forward with trial. I would also like to address just briefly the aspects of due process. Counsel seems to have confused an individual for a corporation. The corporation, an Indiana corporation, has officers. In December of 2025, it amended its filings with the Indiana Secretary of State to add officers to the corporation. The individual, Mr. Chudin, who cannot be here today, is not Select Corporation. As a matter of law, he is not a party to this litigation. Select Corporation is a party to this litigation. Regardless of the briefing and the efforts to try and make it an alter ego, if you will, it is not. They are two separate entities, and there is no due process implication for Select Corporation because they have a witness who is unavailable, Your Honor. For those reasons, we request the continuance be denied.
Mr. Zalet, anything further on that issue?
Only that even if due process doesn't apply, Your Honor, and I don't know, I don't necessarily agree with that, but I don't need to discuss it here. There are principles of fundamental fairness, and we think those should apply. And that's all I have in reply, Your Honor.
Motion to continue the trial is denied. What's your next issue?
Your Honor, in light of the court's rulings and in light of the agreement to dismiss the counterclaim, Select is exercising our right under Ohio Rule of Civil Procedure 41A to dismiss our claims without prejudice. The Rule 41A notice of dismissal is being filed electronically with the court right now. And we thank the court for its time and effort. Apologize for not raising it in the room, but I wanted to understand on the record the procedural situation of this case. Thank you, Your Honor.
Anything on that issue, Mr. Dunn?
God, I think the rule's clear enough on that issue that I don't have anything in response to the voluntary dismissal by Select Corporation. I would bring up, given on a separate note, Your Honor, the sanctions that are pending continue. And we had the court's order last week and its pretrial order granted the filing of that under seal. And I will be filing today the affidavit for attorney's fees for the motion for sanction in part as it pertains to the defense of veteran logistics.
Mr. Zalet, anything further on, I guess, this new issue now that is, okay, so let's tighten up the 41A, nothing further on that issue. And then now we have the new issue with respect to the sanctions affidavit.
Correct. And if I may, just to be clear, Your Honor, at our last hearing and discussion with Judge Oda and at the pretrial, he indicated to file the motion for that to be placed under seal. We filed the motion to place it under the affidavit with the specific billing information under seal. He granted that as part of the final pretrial ruling last week. And so I have prepared a motion to file the supplemental affidavit with attorney's fees under seal and provide a copy to counsel once filed, Your
I'm trying to remember the motion under seal, but I'm not disputing that, and that's all.
Eric, it's not the motion that's under seal. It would just be the affidavit with my individual billing records that would be placed under seal.
We haven't received that yet.
Correct. No, it's ready to file here.
All right.
Okay.
So
Just as a housekeeping matter, I understand, and I know Mr. Fisher just left, but it would seem to me that you need to read the counterclaims. I know we've done that on the record. Are they going to do an entry with respect to that? Do you want me to do an entry with respect to the counterclaim before the 41A gets filed? Because you indicated, Mr. Zalet, that you filed it. It has not hit the clerk's filing yet, but I want to make sure all our ducks are in a row with respect to that, so there's not any issues.
Your Honor, I don't have any issue with that as speaking for the intervener. If the court goes ahead and files a dismissal with regard to that. So we said those claims have been totally resolved. There is no counterclaim anymore.
Okay, we're going to paper that up, right?
Yes, sir.
So you guys are going to file a notice of dismissal of counterclaims.
Yes, sir.
Okay, let's get that filed soon. And then once that's filed, then you guys are going to file your 41A, right?
I believe it's been electronically filed while I was talking, Your Honor. But
Okay.
can I go back to addressing
Okay.
you?
Going back to that issue then.
A couple things. First of all, from a procedural standpoint, I can't agree right now that the attorney's fees portion of that case survives a Rule 41A dismissal. I'm not prepared to discuss that esoteric point right now, Your Honor, but if it does, and I think this was discussed at one of the last hearings with Judge Oda, and that's why Mr. Dunn is filing what he's filing today. We would need, as happens in these situations, the opportunity to review the billing records, possibly have some limit.
Days of Mr. Fair. And there you're first. That's okay. I know. Why are you starting up as Monday this way? It's Tuesday. That's why. See? Sorry. That's why I can't give you any time off. I did. Why are you yelling at me? I had a peaceful President's Day, and then court does call the case of Patrick Totora versus Martin Younts and Teresa Younts and all occupants.
Good morning, Your Honor. May it please the court, Eric with ASP 65354 on behalf of plaintiff.
Good morning, Your Honor. Darwin Fair, P number 31266 on behalf of the defendants and all occupants.
All right, this is the plaintiff's motion. Correct?
Yes, Your Honor.
All right, go ahead, sir.
Thank you, Your Honor. Your Honor entered an order of eviction on July 1st, 2025. The defendants filed an appeal of that order of eviction. This court then ordered a bond on July 11th. The court amended the bond on September 15th. And then the defendant's appeal was dismissed on January 27, 2026 by the circuit court sitting as the appellate court. Therefore, with no appeal pending, we're asking this court to be able to execute on the order of eviction that this court entered on July 1st, 2025.
Mr. Fair.
Thanks, Your Honor. First of all, thanks for allowing me to appear by Zoom. My clients really appreciate that. With regard to our argument, let me just say this, Your Honor. There's three issues. Number one, the underlying case is actually before the Michigan Court of Appeals. That case has not been decided by the Michigan Court of Appeals by way of delayed application for leave to appeal. So with regards to the underlying case of this matter that's before the court is still pending. Number two, with regards to the Washtenaw County Circuit Court, I have been retained to appeal that case, so we intend to appeal that forthwith. And then number three, with regards to escrow. And Judge, let me just say this with regard to escrow. My clients just do not have the financial wherewithal to make escrow payments. And let me explain why. As the court knows, this is a storied case. There have been a number of properties involved, the most important of which have been my clients' actual business in which they derive revenues. That has been turned over to the plaintiff. And so my clients have a huge financial distress as a result of it. And I would also add that that property, the equity in it, is my understanding around $2 million that the plaintiff now has. And with regard to this property that's currently before the court, this is their home. And the equity on that, my understanding is around $2 million. So we're asking, Judge, that two reasons for a stay. Number one, the underlying case in the Wayne County Circuit Court is still pending. And number two, I have been retained to file an appeal of the Washtenaw County Circuit Court. The bottom line is no one knows what these courts are going to do. If they rule in my client's favor, it's going to obviously be a problem for the plaintiffs in this matter. So it just seems to me this last piece of property, which is the home of the defendants, be stayed pending the outcome of the appeals. Thanks, Your Honor.
Any additional response from the plaintiff?
Yes, Your Honor. Regarding the escrow order, this court made it crystal clear in its amended bond dated September 15th. As long as there's an appeal pending, with Mr. Fair's arguing there is an appeal or there's going to be an appeal, the defendant shall post $5,823 per month commencing October 1st. So as we sit here today, they are $29,115 short on escrow. So if this court is going to entertain a stay, I would ask the court to order that if a stay is entered, they must post the $29,115 forthwith and continue that amount.
Well, this court is not inclined to issue the stay. If the defendants wish for a stay in this matter, they can certainly request it of the appellate court for a stay on this. However, to the extent a stay is granted, all back escrow must be paid into this court prior to a stay of the writ. In this case, that will be my rule. And certainly the Court of Appeals or whatever appellate court can overrule that. But if they do issue a stay, then this court believes that all escrow should be paid, as that was a condition of the stay pending appeal and is consistent with the court rule. I have read the order of the Washtenaw County Circuit Court. I believe it to be an order. They have held that decision. The court will do two things. The $7,500, which is currently in escrow, will be released to the plaintiff. And I am signing as we speak the order of eviction. That order of eviction may issue and may be executed on. So,
Your Honor, if I may, if we're allowed to appeal or ask the Michigan Court of Appeals for a stay, we would need time to do that. We can get that motion out as soon as we file the appeal. So I'd ask the court to stay the eviction until the Michigan Court of Appeals has made a decision on our stay.
absolutely not, Mr. Fair. I'm not going to stay this any longer.
Okay, well, Judge, what about with regards to the 29,000, and I don't have that exact amount, 29,000. Mr. Ledez, how much did you say that is owed in escrow?
$29,115 from October through February for at $5,823 per month.
Okay, and Judge, what if he posts that amount? Then if he posts that amount, he apparently
You
won't
would
be
need to
evicted.
have an appeal pending and that, but I'm not staying my order. So
I understand that, Judge, but we can't get a stay with the Michigan Court of Appeals until the appeal is filed. I intend to file that forthwith.
But you can indicate in your appellate paperwork that this court has denied the stay. And then they can act if they so choose to do so.
Yeah, and I understand, Judge. The only point I'm making is the Court of Appeals, and I've done these before, the Court of Appeals don't give you an answer overnight. I would say, because here's the process. The process is that you ask for appeal bond and you ask for
I understand how, Mr. Fair,
Yes.
I understand how the process works. You've done it 5 or 6 times in my court, so I certainly understand it, and I know how it operates. What I am indicating to you is I am not staying the order of eviction. The order of eviction will issue. If you may have an order indicating, or you can indicate to the Court of Appeals that this court has denied the stay, and then you can choose to do so. You can, if they decide to act, if they will act in time for you, then they'll act in time for you. If not, well, this is where it's landed. Okay. I have signed the order releasing escrow, so that won't be an issue. And I also have signed the order of eviction, so that may go forth as soon as it can go forth, unless it's stayed by an appellate court. All right.
Thank you, Your Honor.
Thank you. Pleasant Lake versus Christopher General. You may want to give that to you. Okay. Sign the order.
Good morning, Your Honor. David Morris on behalf of Pleasant Lake Park.
Good morning.
I'm Christian Obiaga.
What are you trying to hand my bailiff?
I tried. I tried to turn this into the clerk, but she's like, oh, your time's kind of running out. You should just go in the courtroom. Giving it to you is like the quickest way.
What is it?
It's just a summary of the reality since January 31st till today. I could read it.
The reality of what? Of the household or of life in general?
The reality of this court case, Judge.
Well, you have to show it to the plaintiff before I'm going to even begin to look at it. Do you mind?
I don't mind. No, this would be his argument today, it's just a roadmap to his argument.
All right.
I just have a couple comments that I forgot to put in there.
Sure.
Like, this is my favorite sweatshirt. And like, this has all been eaten by rats. There's here, like the sweatshirt underneath has been eaten by rats. I've lost 2 pairs of Michael Jordan tennis shoes that are eaten by rats. These pants are eaten by rats. My really nice pair of Kappa pants that were like eaten by rats. I removed everything that I could from that house that's rat infested, that's owned by Mr. Weasel. But like, due to my disability, I couldn't move like a couch and table and chairs. But I had to like cut my king size mattress in half. I cut my dresser in half, all with a chainsaw. Took me, and then I cut my mattress with a knife. So like I know he's withholding the deposit because I left a couch in there, but like, I did literally as much as I could, like without taking myself to worse. So.
Good morning, Your Honor. We're on today's final settlement conference. Plaintiff is requesting, last the court acted, Mr. Janowiak was ordered out by January 31st. He did that.
Right.
He vacated the premises on time. Plaintiff was withholding security deposit. We haven't had a forwarding address given to us.
It's a P.O. box because I'm homeless.
But the rent has been withheld for the security deposit has been withheld for unpaid rents, not for damage to the premises. There was some furniture left, and I would say excessive filth and trash, which demanded cleaning, but that hasn't been, we haven't charged for that at present. And so plaintiff.
Don't mean it. How much was the security?
The security deposit was $1,000.
Okay.
The outstanding rent, including the gas bill that was never changed over to his name.
It was changed on the 31st.
Sir. Hold on. I will let you respond. I always do. But go ahead.
Thank you, Your Honor. The unpaid rent and gas bill is $4,005.19. If Your Honor were to, so if we apply the security deposit, the amount outstanding is $3,005.19. If Your Honor were to disperse the escrow funds, unpaid rents would be $1,770.19. And so that's what plaintiff is asking for today, Your Honor. I can make additional arguments for why I believe there's no tribal issue in this case. If that.
The DTA was taken out on the 30th. Now it's gone by
the 30th of January.
On January, yeah. And then that is a straight lie. I mean, he also
hold on. He didn't say that you didn't take it out of your name. I mean, you're not charging for the 14 days, are you?
Correct. So my understanding is that he was required to put the gas into his name, and that either didn't happen or went unpaid, one or the other. So I believe my client's books records show that they were just auto paying the gas over the course of his lease.
That's not.
And how much is the gas of this amount?
We're talking about approximately, I have it broken down by month here, but approximately $200.
That is, I've been paying my DTA every month since I've been there. That's a straight lie. Like, that's a pure lie. Like, swear to God.
Okay,
That's a pure
so
lie.
hang on.
All the records are there. I mean, how can you lie about that?
But hold on. You didn't pay the rent, so
I know I owe DTE like $400. That's it.
well, they're only saying it's about 200 that they paid over the time.
I paid my DTE bill. I paid all the bills that I needed to pay up until this rat infestation was not taken care of. And then they lied about the rat poop and they didn't.
Okay, but hold on.
This is a nightmare.
The security deposit can properly be deducted pursuant to statute against back rent. If there's $1,250, I think it is, in escrow. If that's paid over to the plaintiff, they have the $1,000. Your balance with your unpaid rent and the gas bill, but hold on, would come to the $1,770.19. If I were then, and maybe over the objection of plaintiff, but again, I really don't have a tribal issue and I don't know if plaintiff wants to try it over $200. If I were to give you credit for the $200 gas bill that they're collecting.
That's it, just $200 over the whole time, not $200 every month. I just have this understanding. I'm sorry.
Well, if you had listened to what counsel was saying, that's what he's indicated to me, that it's about $200 that they've paid. So if I give you credit for the $200, that would bring any judgment amount to $1,570.19. So I give you credit for the gas.
So I'm disabled and homeless. I can't afford to pay anything. I'm barely eating as it is. And I lost my job because of this rat infestation. I worked from home for AAA. There's a full-blown rat infestation in the house. You got my next door neighbor to lie about it. Who is Steve?
Sir, I've been through that initially. I think it was badgers. Then I think there was a beaver that came up.
Yeah.
Then that transformed into mice. And then they became rats.
Yeah, it just compounds.
And I know all of those rodents running around. I know.
I'm not blowing smoke. I never blow smoke at the judge.
No, I'm not saying that you're blowing smoke. I'm just saying that's a lot of vermin.
It's a lot.
In one spot.
And eating my clothes, eating my food. Look at this. Clothes. My clothes are eaten. I've had to throw away at least $500 in clothes because they're just lying about it. This is an inverted nightmare.
Sir, I don't have anything to try. What you've asked me for, and I've read over what you gave to the court, you want the escrow back. I don't think that's proper because the rent hasn't been paid. Also, in looking at everything in regard to this, I don't see where you would be entitled to any abatement necessarily of any rent in this, or that they're gonna need to pay you damages.
So the damages are my clothes have been gone. I lost my job because the rats were literally underneath my bed. They were nesting inside the dresser a foot from my house. I mean, a foot from where I lay my bed, where I lay down. I mean, there's a rat's nest literally underneath my bed inside the house, and they lied about it while we were all standing in rat poop. And then this kept going on and no professionals were
Sir,
hired.
I've listened to you every time you come here. I understand what you're telling me. But just because you keep repeating it doesn't make it true.
I know.
You would have had to substantiate that and you haven't. And so all I'm here to do today is we've dealt with the possession issue. Now we're dealing with just the monetary issue. And I don't think there's an issue for me to try regarding the money.
I can't afford it.
Okay, listen,
I swear to God, I can't afford it.
okay.
I mean, I'm literally on SSDI.
But-
I'm homeless.
And that may become their issue regarding any amount I give in collection of it.
I mean, I'll have to file for bankruptcy. And then, I mean, that all washes away. If I file for bankruptcy, then
Then he gets, well, I don't know what the bankruptcy court is.
it's washed. I mean, you are talking to a disabled street kid that was forced out of his home because of rats and lost his job because of rats. While the whole time the landlord is saying, you're lying, there is no problem. Then I have professionals backing me up. And then I have him saying that like, oh, he's told other neighbors that he's gonna shoot me. Where is that neighbor? That's defamation. I mean, I know that's like a different court case, not to go get a lawyer, blah, 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 blah. I know we're just talking about money today, not defamation. That's a different case. I get it. I'm not dumb. But I mean, like, I've been defamed. I've been put on the street. I have lost my job. I've lost my clothes. I've lost my health. I've lost literally almost everything because Mr. Weasel is not maintaining his property. I mean, I'm repeating myself because I'm just expecting you to just slam dunk on these people and pay me and shame these people and wish me well. That's what I thought. I mean, you have a reputation of being the all-star judge in Michigan. I expect you.
I don't know if that's the case.
I mean, I'm just being honest.
My kids think of me that way, but I don't know anybody else.
I mean, I'm not
No,
gonna say-
listen,
if I know you're
listen,
good-
sir, listen. You may have thought you knew what I would do in this case. There are attorneys that come in every day thinking they know what I'm going to do, and then they become greatly surprised. Because what I'm going to do is I'm going to follow the law. I may feel for you, I may have sympathy for what your plight is, but I'm going to follow the law. That's how it works.
That's what I want you to do is to follow the law.
And that's what I'm going to do. And what I'm going to do is I'm going to find that there's no tribal issue. I am going to give him credit for the $200 gas bill. So I'll award, and also I will not charge him cost. So I will award a total judgment amount of $1,570.19. The escrow will be released to plaintiff. That is the court's ruling. Thank you.
Thank you, Judge.
I did write it.
Thanks for your time, Judge.
Thank you, sir. Did he salute you? He did. Mr. Brown. I think we all need to salute you. Anna did. Anna. Uh-huh.
It's good to go.
Yeah, they're good. Go ahead. Can I go off for a moment? Please, please, what?
We have $4,394 worth of unpaid fines and restitution. You have a drunk driving charge pending a pretrial on February 20th. So you got arrested for drunk driving while you're on bond for drunk driving. That's not good. I remember your name because your parents named you just in time, TYME, so your name's memorable. Rhonda Ives is your attorney.
Yes, sir.
So I'm going to show a plea of not guilty. I'm going to appoint Rhonda Ives. And set an attorney pretrial for Friday. You're going to be here anyway, 2/20/26 at 8:30. 5th, 2610 SD. How'd you get here today?
My mother drove me.
I bet she was happy about that.
No.
Thinking about setting your bond at about $10 million. We don't look very good if somebody kills somebody on a drunk driving accident while they're out on bond for drunk driving. So this is something we need to pay attention to. I don't know if you're sobriety court material or what. The earlier case, not to mention, you've got thousands of dollars of unpaid restitution in a malicious destruction of property case, and you've got multiple other unpaid, oh, I guess they're all set. You got unpaid disturbing the peace from 2020. So there's a high likelihood of jail in your future. But you got competent counsel and did they put any bond conditions on your second arrest?
I believe so.
No alcohol, test as directed?
I don't know about the test. I just know
Well, no alcohol.
Yeah.
I'm gonna test you, or Judge P will test you when you
That's
come in
fine.
here on Friday. If I gave you a test right now, what would it show?
No, I'd pass. I haven't drank since the second charge.
How about marijuana?
I'd fail for that.
Yeah, I bet. A high percentage of our drinking driving cases probably also have marijuana in their system, but we don't always test for that. Anyway, it's time for you to get a handle on what's going on here. I'm going to send you out with the court officer. We're going to get an attorney appointed to represent you, the same one, and you're going to deal with both of these on Friday. All right, you continue to comply with the terms of your bond, and I want you to start paying on all this unpaid stuff. We can wipe some of it out with jail, but we can't wipe out restitution. All right, you go to the court officer.
Right. Every day.
All right, we're working on it. Robert Alexander.
Morning,
Good
Your Honor.
morning.
Dan Schwam, P61476 on behalf of Mr. Alexander.
All right, give me that again.
Dan Schwam, SCHWALM, P61476.
Good morning, welcome to Centerville.
Your Honor.
Have we met before?
It's been a couple of years, but yeah, I was working as a prosecutor in Calhoun County, and we had a special sentencing.
Oh, yes, I
handled
did.
Contractor case. I don't know if you remember that one.
Yeah, well, the guy's still on the lam.
Yeah.
We never have caught, I thought your name was familiar, but I haven't. I still have the file. He's still
AWOL with open warrants.
Doesn't surprise me.
I'm retiring in December. I hope they catch up with him before then.
Congratulations.
Well, I have mixed feelings about it. The state of Michigan tells me I have to retire. And somehow I've lost your client's file here. I haven't lost it. I don't have it. So what the deal is, why don't you guys have a seat? It'll be more comfortable. That'd take me a minute. Well, it's in the AS400. It's in here. I don't think I'm crazy. Don't have the file. I don't seem to have Robert Alexander, 26193FY. He's not on the list. He is in the AS400 and on base, but he's not here, and I don't have his file. Robert Alexander, 26193FY. Let's click into it. Charged with interfering with the crime report. It's alleged that on or about February the 7th, that you interfered with Madeline Simpson, who was attempting to report a crime committed or attempted by another person attempting to commit domestic violence. The way this is charged, it's now a 10-year felony. It's often interesting. Assaulting somebody is a 93D misdemeanor. Interfere with the phone is a 10-year felony. Anyway, you're also charged with domestic assault upon Madeline Sue Simpson. The fact that you wore a tie and a coat shows that you show respect for the process. That doesn't happen much anymore.
Yes, Your Honor.
Do you still live at Marathon Drive?
No,
That's where Miss Simpson is?
no, she's in 705 East Broadway,
All right, well, don't tell me anymore, but where are you staying?
349 Love Court.
All right, just tell me the town.
Oh, Benton Harbor.
Okay. Because this is a felony, I don't have jurisdiction to take your plea. He's not on the list, even on the list, but what would be the prelim date and PEC date?
Your Honor,
Yes?
the victim that's here on that case, she wanted to address the court. I don't know if she'll take her at the moment or not. She wants to address the no contact order.
All right, Ms. Simpson, would you come up to the podium? None is worse than watching somebody blow their nose on video, but I've been doing that a lot lately. Are you Madeline Sue Simpson?
Yes, Your Honor.
You're the complainant in this case. What would you like me to know?
I just want the no contact order to be lifted and that I don't feel unsafe or harmed by any means.
I don't want your street address, but you're staying in Three Rivers?
Yes.
And he's in Benton Harbor? Do you have children together?
No, we are married though, so I have a son, he has kids.
But you don't have any children together?
Not together, no.
Okay. That's often an issue, custody, visitation, that sort of thing. It's a standard condition in assault cases, even regular domestic assault cases, of no contact. Certainly in a felony case, I don't know the facts. In fact, I just opened this file like 1 minute ago. I also go by the theory that you don't know what you got till it's gone. Making you not have contact with each other makes you appreciate how much maybe you ought to respect each other when you do have contact. So there are several reasons. The primary reason is to protect the complaining witness. You don't want people getting re-assaulted, and unfortunately it happens more often than we like. Secondly, you don't want the complainant either overtly or covertly trying to alter your testimony. I love you, I'll never do it again. Please let me come back. Or I'm gonna hurt you worse if you testify, both of which happen again more often than I'd like. So I will note that you're requesting that bond be amended, but I'm leaving the no contact provision in place for now. This isn't gonna just sit idle.
Your Honor, may I add something just that may impact your decision?
Yes.
So my client, since this incident, he's actually started to attend anger management courses on his own. I have a letter that from Kieran King, who's a licensed social worker. He's met with her. He's going to continue to meet with her. He's taken this very seriously. I think if the court were to allow peaceful contact, he has no criminal record at all. I don't think there's going to be any issue whatsoever in this case. He's very serious about trying to rectify the situation and avoid the argument. If you look his name up, you won't see he's ever been in this court. He's at this age, you would see him if he was a troublemaker. He's definitely not.
Judge. Hi. Yes, I'm sorry, I usurped your seat, but thank you. Everybody's in the wrong spot. But yes, Mr. Josh Robert is here from the prosecutor's
So as
office.
everyone's been talking, I've had a chance to look over the file. If the defendant wanted to enter a plea today to DV first with the deferral, be placed on the probation, he can continue in that counseling that he has. We'd have no objection to that. The case could be resolved and they could move forward. We dismiss the felony count.
All right, it's good to have somebody with authority in the room. Thank you, Mr. Robert. Why don't you sit down for a minute, Ms. Simpson? All right, what you're charged with is a felony punishable by up to 10 years in prison, and an ancillary charge, probably the more germane charge, domestic assault or domestic violence. Domestic violence is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Your lawyer says you have no previous criminal record, and I guess I'll take that at face value. Mr. Robert, the chief assistant for the prosecutor's office, says we can take care of the whole thing today, including the bond issues. If you enter a plea of guilty to domestic violence, misdemeanor punishable by up to 93 days in jail and a fine of up to $500. They also do not object to a domestic violence deferral. There's a special statute in domestic violence cases, and your lawyer is well aware of it if he was a prosecutor, that allows the prosecutor in their discretion to allow the court to defer the conviction. You're already in a domestic violence treatment class, which I would order. If you were to plead guilty to this charge this morning, the complainant is here, I could do the sentence today. I could put you on probation, order you complete your domestic violence treatment program with other conditions. Says you were drunk, there's going to be a no alcohol condition. If you successfully complete the probation, the charge could be taken off your record and there would be no record of conviction. I could also lift the no contact provision because the complainant is here, so I don't have to wait 10 days to do the sentence. And she wishes me to lift the condition. So we can take care of the whole thing right now. It's a very busy morning, but we'll make time for this. Mr. Schwalm, you wish to have a chance to discuss that with your client?
I would, yeah, there's a lot of ancillary consequences, gun rights, et cetera. And I'd like to go over those pros and cons with them before allowing him to answer the question, if that's okay.
No, I don't.
I
I don't mind at all. Now, if you get convicted of domestic violence, it goes on your record as a criminal conviction, prohibit you from using or possessing a firearm for 8 years. That's important for a lot of people. If you're in the military, if you're a police officer, if you just like to hunt or shoot, you can't use a gun. If you complete this probation, that firearm provision does not go on your record, and there's no public record of conviction. The state police keep a record because you only get the deal once. But if someone to run a criminal history on you, it wouldn't show up. So Mr. Schwalm is cautious and he wants to talk about this with you. And I don't have any objection to that. So why don't you guys go discuss Mr. Robert's plea offer, and we'll see what we're going to do next.
Thank you, Your Honor.
All right, sorry that one fell between the cracks. It was on the list, wasn't on my list, and I didn't know it was there, but we did it. Cody Ellis.
Oh, no.
Ms. Camfield, are you here on PECs too, or on?
Kind of everything. I have a piece.
You're always kind of here on everything.
I have a PEC and I have some pre-trials this morning.
All right, thank you. Let me know if you need anything. Good morning, sir. Are you Cody Jake Ellis?
Kotai, but yes, sir.
Kotai.
Good morning.
I'm sorry, your name's probably been mispronounced all your life.
Yes, sir. I get it a lot.
That's on your mom and dad, but I'll try to remember. Kotai Ellis.
I got weird heritage.
Okay, all right. I guess we all do. You're charged with assault and battery. Take a look at your case. We're going to put you in the back room. Mr. Ellis, you're charged with assault and battery. It's alleged that you assaulted Bradford Smith in Three Rivers on April 25th of 2024. This is a misdemeanor punishable by up to 93 days in jail and a fine of up to $500. This was authorized by our old dear friend Melissa Halleck. And it happened 2 years ago. At the probation center. Sheesh. How did you come to get arrested recently?
I ended up having a child support warrant that I went in to take care of. And on top of that, they told me finally, I knew about this charge, but it was always I had to appear in person, but I lived 2.5 hours away with no vehicle at the time.
Where do you live now?
I live in Somerset.
Somerset, Michigan?
Yes, sir.
Where's that?
About 2.5 hours away. It's about literally 15 minutes further than Litchfield.
Oh, it's in Hillsdale County?
Yes, sir.
Never heard of it. Mr. O'Bear, I'll put you on the spot again. Is this the kind of thing you would take a disturbing the peace to resolve it?
Sorry, Your Honor, I wasn't listening to what this defendant's name is. I can look it up quick.
Coty, Kotillis, ELLIS. You didn't know I'd be drawing you into this. Reminds me of the dude telling the Malibu chief of police, I'm sorry, I wasn't listening. Just before he throws a coffee cup, it hits him in the head.
If I can, may I
Don't say anything yet.
Yes, Your Honor, I would take a disturbing the peace on this case.
All right, once again, it's good to have somebody with authority right in the courtroom. This is 2 years old. You got in a fight with another guy at the probation center. The prosecutor would reduce this to simply disturbing the peace, which is an old-fashioned simple misdemeanor, punishable by up to 90 days in jail and a fine of up to $500. Normal fine for that is $200, and you've posted $100 of bond. Are you willing to plead to disturbing the peace?
Yes.
Thank you, Mr. O'Bear. All right, disturbing the peace, I say this about every day. It doesn't matter who was right or wrong or who started it, but was there a quarrel, argument, or disturbance in a public place? Did you get into an argument with Brad Smith?
Yes, I did.
What was it about?
Just different views.
All right. How long were you in jail before you posted bond?
5 days.
Oh, boy. All right. He said you put raw eggs in his shoes and then.
That was all after the fact.
All right. But anyway, scrambled eggs isn't so bad, but I hate when you put raw eggs in my shoe. All right. So did you end up socking each other?
Yeah. Yep. I caught him in the bathroom and yeah, I assaulted him.
All right. What are you doing now?
What is that?
What do you do now?
I work and raise my 2 little girls in cage fight. That's all I do.
You raised the girls in cage fight at the same time, or?
No, not at the same time, but.
All right. Are you off paper? Are you off paper?
Yes, sir.
Probation parole? All right. All right, I'll give you 5 days jail credit, 5 days, $75 fine, $75 crime victims' rights fee, and a $50 state minimum fee. That's $200. You posted $100 of bond, so you owe $100. Can you pay that today, or do you need time to pay it?
I can literally pay it at the beginning of next week.
All right, I'll give you some time to pay it. You can't got this much of it resolved. You want to finish it. All right, now, I just took your plea, but I didn't advise you of your rights. Do you understand that by pleading to this charge, you give up your right to have a trial? Do I have advice of rights? Yes, giving up all these rights on your advice of rights.
Yes, sir.
Very good. I'm gonna give you 30 days to pay this. I'll give you till March 30th. $100, 330, 25, 26. There's some instructions on the inside. I want you to pay that. And this matter's over and done with. It's going to show us disturbing the peace. Good to go, sir.
Thank you very much, sir.
Okay. All right, that's good to resolve that all at once. Good morning, ma'am. You're seated on the attorney's side. You have to pay extra to sit over there, especially if you're from Colon. All right, let's see who else is here. That's everybody that was on my list. Dansha Gaddy from Kalamazoo, 252688, failed to appear, and there is currently a open warrant. That's on a retail fraud conspiracy. Warrant will remain out. Co-defendant Naisha Pratt also has failed to appear. Good morning, Deputy Meadow. Judge Middleton, could I see Lonnie D. Williams, please? Yep. Thank you. All right, bye. The clerk didn't think I had enough to do this morning, so Shayna brought me that bench warrant. We'll do that while we have Ms. Jackson from the Public Defender's Office. Maisha Pratt also failed to appear with a co-defendant conspiracy to commit retail fraud. There's a bench warrant already out. Alexander Rivera, no insurance. He's also from Kalamazoo. And we get these guys together. I could carpool down here. That is file 26171 SM. Let's see what the deal is there. We haven't even gotten to our pre-exams, and we have lots of them. That's the first fail to appear in that case. We'll do an order to show cause on Alexander Rivera. If anybody knows him, tells him we need to get in here. Order to show cause, tell him to come. If he does not come, we'll issue a warrant for his arrest. Armando Santis, drinking driving charge. He previously failed to appear. That is file 2660. Oh, yes, it is. I got an email. Meg Bauer was here on a case late Friday. That's her laptop. So why don't you plug that in? Why don't you unplug that and we'll set it over here and we'll keep it safe. Tell Meg we'll keep her laptop safe after we go through it. Armando Santis has failed to appear for the second time. High blood alcohol level, want to do a bench warrant. $1,000 cash or surety bond, no 48-hour hold. It's a serious charge and he's failed to appear twice. Brian Swinehart. But is he in jail? No. First failed to appear, we'll do an order. That's an ordinance, Tim. You waited all morning for that and he didn't show up. So do you have other reasons to be here?
No.
I'm sorry.
Okay.
All right, that finishes our standard arraignments. Ms. Ives, good morning to you.
Good morning, sir.
I had a young man, Justin Time Harrell. You have a pretrial with him on Friday on a drinking driving charge. He got a new drinking driving charge.
Oh my, okay.
So I appointed you on his new charge and also set that for Friday. So now you have two cases with him on Friday instead of one.
Sounds good. I think all the assignments this week come in to me anyway, so
All right.
it's all good.
All right. Good morning, Mr. Williams. Can you hear me?
Yes, sir. Good morning.
Are you Lonnie D. Williams?
Yes, sir.
Of course, I know you. I need to identify you for the record. This is file 252220 ST. You got charged with driving suspended in October of 2025. You got arrested and pled not guilty to that charge. We appointed attorney Casey Strong to represent you, set an attorney pretrial for January of 2026, and you promptly failed to appear. So we waited a while, then we issued a bench warrant for your arrest. How did you come to get arrested last night?
I got arrested Friday, but going to the store.
Were you driving?
Yes.
Did you get a new ticket?
Yes.
Okay, well, let's try to sort that out. I should have looked before I just did this. Shayna, do we have a new ticket on Mr. Williams? Has it even made it to our attention yet? Well, the good news is I'm going to reset.
You are Raymond Johnson, correct?
Yes, sir.
All right. As you probably know, this isn't good.
Yes.
All right, you charged with evading arrest or detention with a motor vehicle. And
Yes.
when the police have a siren and they have the lights, what are you supposed to do? Stop as soon as possible. Yeah. And that carries with it up to 10 years in prison, if it were only that. So you got this 2019 forgery conviction out of the court next door. After that was final, you picked up in this court unlawful possession of a firearm by a felon in 23. And also, well, 2 unlawful possessions of firearms by a felon in 23. But the point of it all is, if you're found guilty of this, you're looking at 25 minimum to life in prison. Do you understand that? You're habitual, what they call habitual felon, which is what you don't ever want to be.
Yes, sir.
But it's choices that we all make.
Yes, sir. Yes, sir.
All right. Langston Adams is your attorney, very good man, fine person. I've known him a long time. We both come from Port Arthur.
Yes, sir.
It can help guide you through this, but you've got to do your part of following the law for a change.
Yes,
I mean, you've been messing up now
May I say something, Judge?
since 2019, and it's been consistent. What do you think we want to do to those?
Judge, I was gonna take it from the initial docket and actually put it on the announcement docket.
Oh, okay. You know, you're not even if you went to trial, you're not eligible for probation. You know, you weren't eligible for probation after the first felony conviction, which was three convictions ago. So you put yourself in a box. You don't have a lot of options here.
You remember last time I seen you, Judge, I caught the gun charge, and I talked about my man.
See, you caught the gun charge. You speak just like the street folks. You were indicted for a gun charge.
Indicted with the
Yes,
gun
sir.
charge, yes, sir. I explained the reason for me having the gun at the time. I don't know if you remember or not.
But I'm not the grand jury. The grand jury indicts.
Yes, sir.
What they hear, the evidence that's presented to them from the DA's office, they pretty much make good choices. That's why you need your lawyer to help you, because like I say, this is a minimum of 25 years in prison. And you don't want that.
You know, I've been selling I've been having my own business since 2021. And
nonetheless, you could lose all of that.
Me being the color that I am in the city that I stay in, it's kind of, you know, it's hard to live out here trying to do positive, and have your own business and run it, and you have to look over your shoulder at times. So I had to protect myself. You know?
Well,
and
don't blame it on how God created you.
Yes,
I mean, in this area, the people who run things don't tolerate unfairness.
Yes.
Okay. So you've just got to follow. This doesn't show anything about race. This shows about bad choices.
Yes, sir.
Okay. Don't talk to them about it. I prosecuted the James Byrd trials. That's me. I prosecuted the two who were executed. Don't talk to me about race. We don't put up with people being treated unfairly. Yes. That's not tolerated in this area.
Living in your city, just, you know, how it gets out to the county. Well, just the race. It's just the city, period. How the people kind of live.
Well, you have a right to pursue your dream as long as you do it within the law. Yes. And if anybody gets in the way of that, that's improper. And we got rules of dealing with that.
Yes.
But everybody gets a chance to try to reach their dream. That's a problem. He's going to put it on the announcement docket. But once again, the minimum is 25 years in prison if you go to trial on that. The minimum. Well, you got to work with him and figure this out. All right, get every say. Thank you. Hey, Don, you've got Richard Allen. Allen us.
Yeah.
Versus Melissa Daly et al.
Beverly CP Sunrise 65 for real properties.
Dominic Camden appearing on behalf of the defendants.
All right. I have before me a consent order for conditional dismissal. I have read over the terms. And basically the parties are going to work toward the defendant reobtaining her Section 8 voucher through mischief. The plaintiff would be allowed access to the property upon 24 hours notice, and the defendant is agreeing to relocate from that property by April 1st, 2026. This is a 4B case, and it's pretty much the terms. It's the court's understanding.
That's correct.
Mr. Daly, did you hear the agreement that was on there?
Yes.
You signed the order of dismissal, not the judgment. You signed the order of dismissal?
Yes. Yes.
And you informed me today that Mishta has actually informed you that your Section 8 was originally revoked inappropriately. Is that correct?
Yes.
And you were in the process of getting that returned?
Yes.
Okay, nothing else.
That will work then. Good. Glad to hear that. It's not going to be such an uphill fight. All right, very good. I will mark this file and sign this order. Case is conditionally dismissed. Counsel, thank you so much for working it out. Do appreciate it.
Have a good rest of the day.
You do the same. Is that it? What?
Till 1 o'clock.
For what?
I know. And we're also, this one has reset on the. Guys, you're done. That you? You're charging to say, felony unauthorized use of another vehicle. It's vehicle misuse today, just not. This carries with it a few years. I just need to and this is principle, and work with the it's on, this 3 going to be there, but the time sound be seen. Grant? Patricia?
We're talking, Judge. They just made an offer.
How's that working?
We're working.
Is she talking? Is she responding?
She is.
Okay. Well, let me know. And Lionel Pluma is Polvo. Is also going to be one of yours. Uh-oh. Lionel Polvo Pluma. I've never heard of such a name, but there is no answer in the courtroom. I asked the bailiff to call into the court, into the hall for good luck with this one.
Okay.
Lionel Polvo Pluma.
You skip it?
Yeah.
Okay.
Richard Alanos, and then Brant's Patricia Johnson.
Yeah, we're working on that one this morning.
She's working on it.
And then
Nice catch. We're gonna have something, an answer here shortly.
I think so.
Okay. I don't mean to call you shorty.
Well,
Shortly.
I'm sorry, coming surely.
Right, there is no answer to the name Lionel Polvo Pluma. There can't be a misunderstanding of who that might be out there. And there is no answer to that name being called here in the courtroom, nor into the hall. Defendant has failed to appear. What was the bond?
Originally 6,500.
A warrant shall be issued for that person's arrest. Their bond is revoked. It is now $13,000. Plus, they must have a GPS device as a condition of their bond, so we know where they are when they're not in court, when they're supposed to be in court. Vernon Williams.
He's here, Judge.
He is here.
Vernon Williams.
That's Katrina Dodson.
I know, I'm giving you those down.
Mr. Williams, and this is his initial appearance. I just got this discovery. Yeah. Announcement documents, we can visit this case.
Mr. Williams. You are,
I don't know what she's thinking. I'm sure she's right longer than.
this crime always has a real, it takes 2 pages to write it out. You're Vernon Bronson Williams?
Yes.
Here in 25 CR 1839. Once again, like before, I'm telling you something I shouldn't have to tell you. Enough is enough, huh? You're going back to 2012 convictions in Jefferson, Louisiana. A felon. It's like another one the next year out of Jefferson, Louisiana. Of course, looks like several different outcomes. After those were final, this states that you committed a crime of introducing contraband into a prison, and you were convicted of that in 2018 out of Franklin, Harris, Louisiana. And those were 2 different charges of that type of crime. And so now you have a 3rd one here. So I'm right in saying it's an habitual felon status. You got the two priors in 12 and 13. Then after that, the 2 in 2018. And now this one, which would be a third-degree felony up to 10 years in prison. The way I'm reading this, you're looking at a minimum of 25 years now, a minimum of 25 to life. Is that right?
Yes, Judge.
Yeah. Well, this is most serious. What do you want to do today?
Judge, like I said, we just got the discovery. I need to visit with Mr. Williams.
4 weeks good?
Yes, sir.
All right. Follow his advice. He's going to try to guide you out of the forest that you put yourself into here. Nathaniel Claude, John, yes. Multi-felony day. What you want to get at the beach? It says after like 97, which about marriage, Louisiana. So if all of that is proven true and you're convicted of this, you also are looking at 25, habitual theft, a minimum. Then you're not eligible for probation if you have one or more prior convictions of felonies. Okay. Now, what are we doing? Our drive. Yeah. Did you drive up here? Okay. You can't operate a motor vehicle without an interlock device, which you have to blow into and you have to pass, showing that you're not. And you have to pass, showing that you're not intoxicated for the car to start. If I find out you're operating a motor vehicle without it, I'm going to put you in jail without it until we can figure this thing out and resolve this. A vehicle, it's not a debate. It's just the way it is. A vehicle is nothing more than a 4,000-pound missile. And we got too many cases where people operated unsafely, and we got deaths, injuries, and crime, and weeping, and so forth. But operating a motor vehicle, you don't find it in the Constitution. It's a privilege. You have to earn it, like we all do, by operating it responsibly. So you're looking at 25 to life, I guess. So John is going to reset this for an announcement. Yeah. And I'll give you 4 weeks. So figure out what direction we head when you do it. All right. And be careful about operating in big one. Have somebody else drive you. That's a safe thing. So, I'm tired. Hey, what's up with this? Look at that. I got one more. What are you doing? Who is it? Okay, that was Brent. Yeah, well, I'm tired now. Yeah, yeah. We reset it for 4 weeks. All right. Yeah, William McGinn. That's been reset. Elisa Percy. Elisa Percy. The initial parents. Is that you? And in 25 CR 1867, you are Lisa America Percy. You have to speak out, so she can get, there you go, yeah, yeah, she has to take down and you have to call to be the auditor. Oh, you were calling to the state, you're telling me that they were the building. October 26, which carries with it is curriculum for 2 years in the state, yeah, but it is old following that. Being a lawyer. That's important. You don't even represent yourself. A lot of lawyers. But someone got him in Orange County. They're allowed in that. That's not it. I'm going to need the 4 weeks to talk to somebody with a lawyer to talk to, right? Are you able to afford them? You have to talk to some people. If you can't, you got to be back anyway. Give talk to them if you have the problem. And also this event, you familiar with what we charge. You know what you charge. Okay. Don't, you can't have any contact with this victim. This opponent. That would be inappropriate to affect your life. You don't know who it is. Okay. You've got 4 weeks to get something. You can have somebody different, so you just say something. Is it rolling? I believe, and Sharon Lee. Okay. Pretty well. Are we together? Okay. Who are these two? Are these both of them? Good morning. Who's who? One for the building. Are you Sharon Lee? But Sharon Lee, somebody else. Okay, that's a different case altogether. She's interpreting. I don't know. No, what about Sharon Lee? If I had different case, we had a companion. I'll see. All right, remember the okay, good. So what happens? Stand. Okay. Raise your hand. You speak English, don't you? Yeah, he does. Gotcha. That's it. That's easy. You have to be name. And for you, English and stuff. How long did you speak Spanish? A lot. Have you interpreted your people in functions where people have to speak with Spanish or English and the interpretation into English or stuff? You find those from those people will interpret the English, that's what we do by it goes into the Spanish language that we particularly lower states and do an interpreter his language, Spanish into English, so all of us can understand it. We can place this and we do this correctly, so that we got. We were more people the level. You have to speak out, but you can hear him. But the what would be your point for that? You're not with the point of view. He has to speak the answers, and then we're going to start with it's kind of often. What do you think? I think you were charged with libel. Yeah, it's that. Okay. And this is a second-degree felony, which means you face up to 20 years in prison. if you were convicted. Do you understand? See? All right. Mr. Walker is going to help you. He's a very good lawyer. So listen to him and pay attention to his advice, okay? See, yes, today, what do you want to do, sir?
Judge, it's going to be disposed of today. We're taking care of the misdemeanor down the hall, and that should dispose of this case.
Is that right? Okay. Well, let me know when that is
That's good to me, Judge.
accomplished. You said Dan was working, Dan? Boy.
Yes, he's out today. Good stuff.
Okay. This is, all right.
Cal's working on the misdemeanor.
So this case will be just dismissed then, right?
Yes.
Is that the plan? Okay. Let me know and then we'll get that done. If that's the plan, you're going to be disposing of the case in another court, a misdemeanor. Yeah, I know it's awkward. Go ahead. And then this more serious case will be dismissed. Is that your understanding?
He understands.
Yeah, and for the record, he nodded. Yes. Okay. Thank you. See, thank you. Hasta luego. Sharon Lee. Have a big pleasant change. You are Miss Lee? You speak English?
Yes, sir. Today.
You're Sharon Lee and you're here with Mr. Walker, your attorney, as you know. We're not going to make light of this. This is very serious. First degree felony, money laundering that carries with it up to life imprisonment. No less than 5, no more than 99 years confinement in prison or life imprisonment. And a fine up to $10,000 can also be assessed. So I would say, a good man here, follow his advice. He's going to guide you through this dark passageway that you've fallen into. Fix this.
Yes.
All right. What do we do today?
Judge, I need a little bit of.
You got it. You got it. Is 4 weeks good for 5 weeks? Did I say 6?
I think I thought you said it like a year.
A year?
Well, much, no, sir.
I should live so long.
Whatever grace you want to give them, Judge, is good because the restitution amount is fairly high in this case.
Well,
and it will be something that impacts.
We're going to reset 6 weeks for an update.
6 weeks is fine.
Okay. All right.
Thank you.
I guess restitution is going to be a big factor here.
Yes, sir.
All right. Okay.
And how that's resolved, how the defense approaches that should potentially resolve those cases, Judge.
And you're talking about in both cases, she is charged with first degree felonies in both 25 CR 525 and 526, money laundering in 525. And y'all are working on something that will resolve both.
Yes, sir.
Okay. 6 weeks, we'll see what happens. Okay, thank you. Please give a resub.
It's just what violation.
Judge, we're going to look up his role.
Yes, sir. Okay. Yeah. Scott, you have just one case, Dumas, with 2 cases out of that, right? Charles Dumas, where you would think.
He's president.
Where is he again?
Sitting right by the door outside.
Where? Oh, he's outside,
He's
President.
just sitting by the spot.
You want me to go out there or is he going to come in? Oh,
I mean, if you want to.
oh, Dumas, thank you. What are we doing today on
I
this?
think that y'all,
I know, we've had.
You
You got the 16th.
Okay, we got a note.
I think that.
Come on up,
Sorry, next it.
Charles Dumas. Here he comes, everybody. He's on his way to work. That's what close. He got his work close. You were Charles Neil Dumas II. And you were here with your attorney, Mr. Rennick, who's going to try to help you on this. All right. What we did was we put you on probation back in 2019 for evading arrest or detention with a motor vehicle of third-degree felony. You were placed on 10 years probation. And number one requirement of probation is don't commit another offense. And here we go. We got a new indictment.
Judge, if I may, we've gone through this new case is going to be dismissed for payment of restitution.
This
is a review to see how he's doing on paying it because it was $20,000. I think he's up to.
He's up to 16,000 that he's paid, Judge.
So you
Oh,
want
that is going to dispose of 805?
Yes, sir. Yes, sir.
He hasn't fully paid the full amount of restitution yet. He's getting very close.
What did we mean close? Where all the
I think the total amount is approximately about 23,000.
It's $20,680.94, and he's up to 16,000 he's paid so far. So we're trying to get the rest of it paid off. Then we'll get rid
So
of it.
how are we going to get the other four? What length of time?
What do you think?
What time period? Because
days. Can you do it in 60 days?
Hey, let me ask you this. He's got that amount collected. Has he paid the victim that amount, or is it just in a bank account somewhere?
He's paid a great deal of that amount to my office, and we've sent it over.
Okay,
that was for your instructions, Jeff.
Yeah, because
so we're just for the rest of it.
withheld, the longer it's lost to the victim, and they lose the piece of that money. That's why whatever you get immediately, you get credit. If you get it through your attorney to the state, then they pass it on to the victim. And this is important to you because this is a new crime. You're looking at third-degree felony. If your probation is revoked here because of a new offense like this, you're looking at 10 years in prison. So you got everything riding on getting this paid back soon.
Judge, not assuming what happened per your instructions about him working and paying it back, and he has been trying to do that diligently.
So what's where are we in a time period thing? When's the next payment going to be made?
He thinks he can have the entire amount paid off within 60 days.
Okay. He does speak.
Yes,
I was talking to him, and then I could hear translation by Scott. But yeah, I mean, is that realistic, or are you just sticking your neck out too much? More than him. Okay. But once again, whatever you can accumulate, the quicker you can accumulate it and be able to live, well, you got to pay you got to pay to exist. Get that over to him, to the victim, so that the victim can get as much money as soon as possible. Once this is resolved, they've fashioned out a plan where that case would be dismissed, which is a kind of a special deal. That's not normal. So you got that going for you. And also, we've got this other thing on this motion to revoke probation about failing to remain in Jefferson County. Has that worked out? You went to New Mexico and apparently didn't have permission.
He was working.
He was working.
I want you to work. Just don't, but we still have to know where you are, or else we're not supervising. And that's what we're all about. So we got to supervise you. And if we don't know what you're doing, even if you're doing something good, you're not being supervised. And that's important. So stay with the probation office, keep good rapport with them so that they know. All right. How much time? Thanks.
Male, Landon? Okay. We need to. We need it.
Okay. 1455.